crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Whistling truth, battering news, mixing stories, solving the lies. In this kitchen, secrets are broken. With a spark in our eyes. In the broken baker's kitchen, the secrets crumble like sunrise. We'll sift through clues to find the news. With a spark in our eyes. Broken arrives. Broken arrives. Welcome to the Broken Baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good morning, good evening, good afternoon, whoever you are, whatever you are, what if any you might be. And welcome to this, I don't need this, I don't have Jamie. This short little Friday stream where we will be talking about the motions in the Sarah Boone case. Will she get her glam squad? Will they throw out the police investigation? I, as the due diligent researcher I am, heard someone talk about, well, they clearly violated her Miranda rights. So let's see if the judge agrees with that, or if maybe someone is blowing a little bit of smoke up someone else's tutu to get some of that sweet, sweet anti-grift going. Bonjour, Deborah, ça va? Hey, Christine, how is it going with you? And Melissa, Beth, ADHD, g'day from Aussie. Wouldn't it be g'day from Australia? I don't know why you turned Irish. I do that. It was, well, we were supposed to have it yesterday, but both Marissa and Jess picked it up almost at the same time 20 minutes ago. So I'm going to do the Ricky Bobby. If you ain't first, you're last. Hey, Dawn. And Kimberly. Nigel. Why is everyone named Nigel supposed to be in my brain talking with a very, very posh British accent? I don't know. But I envision that Nigel speaks kind of like King Charles and wears a monocle and says, "Hello, sir," to everyone he meets. Hey, and up. How's Virginia? Good thing I didn't pronounce it in the Danish way. Hey, Teresa. And from Wales, it's 15 Drogues. Just jumped in from Illinois. Hello, Jonathan. I should go back to Illinois. Haven't been there in a long time. Really like the place. I had been refreshing my screen for her docket since 11 a.m. yesterday, straight through the minute the two docs were posted. No spoilers. No spoilers. KCT. Chelsea B, good morning. Hello, sunshine. Listening from my favorite U.S. state, the Ohio State. Go Gamecocks. Oh, you got a... Well, YouTube must be liking me again. And Elizabeth is in Texas. Got a K, good morning to you. And Phoenix, how are things down there? Will I be streaming the Boone trial? Do the Pope wear a funny hat and do bears defecate in the woods? Another g'day from Australia. Well, hello, Defense Rest. And Wicked, good morning to you. Oh, and interesting enough, I found that James Owens is late on his Florida bar fees and is appearing as not eligible to practice law in Florida on the bar's website. Okay. That must be a clerical error. Jemima? Maybe something for you to do over the weekend? Well, that's why I knew you were having a slight Irish accent. I knew your great grandmother. Wonderful woman. Hello, Penilla. Yeah, I'm not saying, but I might have a few crises during that stream. Hello, Jane Doe from Holland. You have a posh Canadian accent. But no, I can't say any. Oh, I forgot to take my poll which states I could make fun of yesterday. I should have a lot more polls to figure that out. But do you also wear a monocle? That could be cool. You are in North LA. Hey, Sophia Starlin, been a hot minute. And Mary Milady. Can I say hi to your daughter? I finally got her to join me watching you today. Jane Doe, daughter, good morning. No, good afternoon. It's afternoon. I wish I could speak Dutch enough to say hello in Holland. Dutch. Probably, if I want to speak Dutch, I should say hello in Dutch, not in Holland. Dankjewel for watching. I think that's Dutch. But welcome, Jane Doe's daughter. And we are a very fun group. If you are sub 13, don't listen to Sue. Does the Pope poop in the woods? That's the question. Hey, Holly Moore. Oh, lawyer, you know, say it isn't a big thing. Okay. Well, lovely Beth. I have to remind you, he is not lawyer, you know, it's know your lawyer. That's official court record. And a fish poo popos waterproof. Exactly. Peter A. the lurker. Hey, Karen. When did you start? How late am I? I'm just running through the hellos so everyone has a chance to jump in here. I haven't missed, you haven't missed anything. Greedy bloke, salutations. That's it. Kirkpatrick. Kirkpatrick. I'm having a stroke again. Good morning, genitals. How do you say hello in Dutch? You have to teach me that, Jane. I'm big in Holland. Howdy, y'all from New Mexico, USA. Hey, Mark J. And Stacy Stace. And Adelaide Lass. I'm glad you got your grubby little fingers on these dogs, Broken Baker. I have been itching to hear his rulings, and maybe I'm ruling to stop itching. I don't recall going anywhere near Laurie Shaver. Maybe you had been hugging Quentin Nixon. He was a little itching yesterday. It's me, the Jesnet, aka Issy. That's her new name. Hey, Kissy. Chrissy, not Kissy, Chrissy. And Joe. I brought a friend to join us for Boone here. Is me, the Jesnet, aka Issy. Lovely Beth. Thank you for bringing your friends. It looks like, no, I was just about to say, it looks like a sack-free zone today, so they wouldn't be scared away. But hallo, Schöner, wie geht's dir heute? And Medina Finn, we missed you yesterday. And now Iris is here. We can get started with all the cray-cray. Oh, we have to say hello to chefist grandma. It must be the most chef of the chefs. But we have this ruling from yesterday. State of Florida v. Sarah Boone. Order on the defendant's motion to suppress defendant's statements at the police station. On defendant's amended motion to suppress defendant's statement at the police station, and on defendant's Second Amendment motion to suppress amended motion, not Second Amendment, to suppress defendant's statements at the police station. This cause came before the court on October 2nd, and we're just blah, 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 everything. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the Second Amendment amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for state, and having considered the arguments offered by counsel for defendant, finds as follow. A. Defendant Sarah Boone is charged by way of information filed with a single count of second degree. On February 24th, defendant called 911 after finding her boyfriend, Jorge Torres, deceased. Deputy Kayla Rodriguez arrived on February 24th and spoke to defendant. See also states Exhibit 1. That's the body cam video from the first arriving officer. Hello. And Julie. Hello. What happened yesterday? We watched the Sarah Boone hearing, but it was just Milo was in here, and I thought it's been a while since we've seen Medina. Hello in Dutch is hello. Good day is Goedendag. Goedendag. Hello in Dutch. No Adelaide last, because we are building suspense. It's to keep people here for long enough so they'll stick around for the ending. It's a trick you use when you're a grifter. But it won't be a long. It's only 10 pages, so it won't be a long stream. And I'm gonna, if Brandy is still streaming, I'm gonna kick you all over there after. She's coming back. I miss Brandy. Detective Kurpsel, homicide detective with the Orange County Sheriff's Office, with 6 years of experience as a homicide detective. I don't know why we need this. And a law enforcement officer since 2013, was the lead investigator in Jorge Torres' death on February 24th. Detective Kurpsel arrived at the scene within 30 minutes to 1 hour of the police deputies arriving, was briefed and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. Is it a happy ending? It's always a happy ending when you're with me. But it's midnight here. It's gonna be, if you stop interrupting me, we can do this in half an hour. Well, that's a long time for me. Hey, Amy from Boston. Detective Kurpsel then made contact with defendant outside of the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. That's the guy with the sunglasses. Defendant's cell phone was collected. After CSI documented the scene, Detective Kurpsel wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews addressed below, Exhibit 1. Detective Kurpsel did not look at defendant's cell phone, including any video, prior to the interviews addressed below, as digital forensic did not arrive until approximately 7 p.m. Detective Kurpsel then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detective Kurpsel and Lowen had an interview with defendant in Detective Kurpsel's unmarked Nissan Pathfinder at approximately 5 p.m. Detective Kurpsel explained that she wanted to have a conversation. Probably will write it differently. With defendant after walking the apartment. Detective Kurpsel testified that she would not have interviewed defendant outside of the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The words routine is not used by Detective Kurpsel in any recording. No, it's going to be, of course it's granted. Sarah Boone is a smart person. Hey, Spacey Stacy. Thanks is donkey in Afrikaan. Well, Afrikaan is part Dutch, right? Hey, Mr. Fedorowski. I love that we have all these different languages we can share. Detective Kurpsel explained the purpose of this interview, including defendant's prior conversation with the Deputy Kayla Rodriguez and Detective Kurpsel's desire to get a further understanding of what happened last night and ask Sarah Boone more detailed questions. See Exhibit 1. Thereafter, Detective Kurpsel began reading Miranda as follows. And all 8 questions on Detective Kurpsel's Miranda card was read as Detective Kurpsel's Miranda card did not have question 9. I am going to read you your rights, but it's just because that's how we do things, okay? So you do have the right to remain silent, okay? Do you understand that? Yes. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? No. Do you understand what I just read to you? Yes. Thereafter, Detective Kurpsel interviewed defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Footnote number 2. During this second separate recording, defendant used higher tier words, including compos mentis. Notice that one. And compos mentis means mindset at the time. Jaw. Detective Kurpsel confirmed that defendant that no additional communication occurred prior to the second separate recording, and Detective Kurpsel inquired of defendant prior to asking any other questions. You do understand that you don't have to speak with me if you don't want to, correct? To which the defendant responded, yes. After concluding the interviews, but before leaving, Kurpsel had a conversation with defendant. No, what the hell is this? After concluding the interviews, but before leaving, Detective Kurpsel had conversations with defendant had about coming. Peter A., can you call this judge and yell at him as much as you yell at me for misspelling things? This is bad English. But she had a conversation with Sarah about coming to the police station the next day to address the pending autopsy, and that Detective Kurpsel would have more questions. Detective Kurpsel did not recall speaking about defendant's cell phone, but had defendant asked about getting the cell phone back, Detective Kurpsel would not have given a specific time frame for returning defendant's cell phone. Detective Kurpsel had no memory of receiving a call from defendant on the evening on the February 24th. Defendant's testimony largely agreed with Detective Kurpsel's testimony, including the timeline of calling 911, speaking with Kayla Rodriguez, and speaking with Kurpsel. As to the 24th interview, defendant confirmed that Detective Kurpsel explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. However, there was nothing evidencing. What? There was nothing evidencing defendant being intoxicated or under influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. She had mouth and really needed her Dr. Pepper. That was more she was hungover. Hey, Colin was in the house. And Boomer, you forgive the spelling errors due to the speed of response. Well, he had an entire day. ChatGPT exists for stuff like that. Hey, Robin S58. New in chat usually don't catch alive. Glad I made it. We are also glad you're here. Everyone, say hi to Robin and wish them a good time here. And Ismi the Shiznith is also new here. Wave to them and say, Hola, ¿cómo estás? That Spanish and means, how are you, in Jamie? Defendant's statement of making a call to Detective Kirpsel between 9:30 and 10 p.m. on Friday 24th from her ex-husband's home does not line up with defendant's own timeline of staying at the scene 10 plus hours, which began at approximately 1 p.m. The court finds this statement lacks credibility. What the? My sweet Boone doesn't lack credibility. Well, hmm. Well, Carla, do you know you can use protection? Then you won't be late as much. You're going back to school. Oh, that's cool. Hope you're starting something cool, like underwater basket weaving, like Valhalla. Defendant claimed that before they left the scene, Detective Kopsel and Lowen would return defendant's cell phone to the apartment. On February 25th, defendant claims that defendant and Detective Kopsel had a discussion regarding the picking up of the defendant's cell phone. Specifically, that due to the Detective Kopsel's pregnancy, defendant needed to come down to the police station to pick up the cell phone. Defendant's sole reason for traveling to the police station was to pick up the cell phone. Footnote 3. Approximately 1 hour and 27 minutes into the February 25th interview, defendant returns to her list of pre-prepared written questions and specifically asks, "Am I getting my phone back?" See State Exhibit 1. The pre-prepared written questions would not be asked if one was told to come pick up a cell phone. I don't like this judge. He's calling my sweet baby girl a liar. The court finds defendant's statement regarding picking up the cell phone also lacks credibility. I will not stand for this harassment of my sweet Boone. Because I won't stand for this. He is tarnishing her good name. He's saying just because you weren't here from the start, can you look up if James Owens is in bad standing with the Florida bar because he hasn't paid his things, and maybe for our stream Sunday, evaluate if it means anything. No, your lawyer says it doesn't mean anything, but apparently he's behind on his bar fees. Yeah, a spray bottle might be needed. I want that boony booty. Booney's bony booty. She's been losing weight. It just hurts when he calls her not credible. I believe her. She told me I will be a millionaire. On February 25th, after Detective Kopsel reviewed some of the extraction of defendant's cell phone by digital forensic and attended the autopsy, Detective Kopsel requested defendant to come to the police station. Detective Kopsel did not want to approach defendant in front of her child at her ex-husband's house. Defendant's worry and concern about her son was addressed by Deputy Kayla Rodriguez. The state and defense agreed that the February 25th interview was custodial. The pitch of defendant's argument is contained in this exchange during the beginning of the February 25th interview. Detective Kopsel, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Appreciate you coming in. Yes, ma'am. I want to ask about these when we have a moment, referring to her pre-prepared written questions. Sure. So obviously, he received his autopsy So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it. Footnote 4 says the court notes that this statement is an accurate statement of the law. See Right v. State 161. While Detective Stroop said, "This is something I have to do when given the Miranda rights warnings. This is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations." This, Mr. James Owens, is case law. The judge just showed you what you had been supposed to put into your filings. This is case law, so they can look it up and say, "Oh, case law says I like this judge now." Where did we? Yeah, just like we did yesterday. Normal protocol, just like we did yesterday. Remember, I read you your rights. Yeah, yeah. It's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you. Okay? Sure. All right. So you have the right to remain silent. Anything you say may be used against you in the court. In court, you have a right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one will be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? No. And do you understand what I just read to you? Yes. So, that's interesting. Should we pass the basket around for him to collect for him to pay his bar payment? Nah, he's going to be a millionaire off this case. I can already answer he isn't. His bar profile shows he's in good standing, and honestly, attorneys forget all the time to pay the registration fees. I have to pay 2 different ones. Okay, thank you. No, she's really bad at hide and seek because she knows where he is. So stupid. I don't understand. Yeah. Understanding there's an underlying dry humor, Danish humor for anyone new. Half of what he's saying is sarcastic. Marissa, you just don't know love. I feel sorry for you. Alkylex, Alkylex. Just think dry British humor is rather sibilant. That could be. Hey, Amy. What they tried to coerce her to do was shut up, which she had the right to do, but as Ron Wright say, not the ability. Holly Moore, from your mouth to God's ears, because coffee nut. As one who has been in that position with a girlfriend who was late twice, I also hate it. It's such a long wait. I quack you up. Yeah, MG Law, the court order is in. And imagine that the judge put in case law, not like the defense who just said, I don't know. What the damn phrasing stuck in your head? Alkylex. Well, you can have it. I don't. I'm promising you can have it. I don't even know how to send stuff. I will probably the ladies can send it to you. That please no. I don't know what you have against Alkylex. I think she was beautiful in those short shorts straddling the bush. Alkylex is an old standard older than time itself. Whew. Yeah, some use it, some don't. It depends. Whether the Miranda warning sufficient. And case law again. The Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provides for a right against self-incrimination and a lot of case law. The self-incrimination clause of Article 1, Section 9 requires that prior to custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in court, that they have a right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to them. Look at all that case law. Both the Florida Supreme Court and the United States Supreme Court have stressed that there is no talismanic incantation required to ensure that Miranda warnings are sufficiently convert. Miller v. State, case law. A court does not examine a Miranda warning as if construing a will or defining the terms of an easement. Dogwood v. Egan, another case law. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. Alterations in original, quoting California v. Prisog. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all his rights. Quoting Coyote v. United States, another case law. The Miranda warnings provided by law enforcement to defendant at the beginning of the February 25th interview is sufficient under both federal law, see Florida v. Powell, quoting Miranda v. Arizona, and Florida law, see Thomas v. State v. Owens, all of this case law. In 1966, the United States Supreme Court issued its opinion in Miranda and established 4 warnings that are required prior to questioning when a person has been taken into custody or otherwise deprived of his freedom of action in any significantly, a suspect must be warned prior to any questioning. 1, that he has the right to remain silent. Check, she got that one. 2, that anything he says can be used against him in a court of law. Check. 3, that he has the right to the presence of an attorney. Check. And 4th, that if he cannot afford an attorney, one will be appointed to him prior to any questioning if he desires. So all of those 4 was given. The Miranda right warning given to defendant in this instant is identical to the exemplary Miranda warning identified in Owens Supra. That's a Toyota. As such, the Miranda warnings given to the defendant in the instant case was sufficient. My sarcastic self in Colorado, everyone looked at me like I have 3 heads. It was a sad, boring state, as you can understand. Self-deprecation and sarcasm is Danish humor. Oh, I've never seen that one before. That's a good grift. She has to know now, after the last-ditch effort here, that her goose is well and truly cooked. No! She's a smart cookie. She's going to get out of this. I still hold out that the judge will see the truth. Whether the defendant's statements on February 21st were coerced. To establish that a statement is involuntary, there must be a finding of coercive police conduct. Baker v. State. Somewhere. Quoting Schoenwetter v. State. Generally, to determine whether a confession is involuntary or coerced, a court must examine the totality of the circumstances surrounding it. Martin v. State. When the voluntariness of a confession is in dispute, it is in the state's burden to prove voluntarism by a preponderance of the evidence. Harold v. State. Look at all this case law. There was no misrepresentation of the law regarding any defense. See Johnson v. State. No quid pro quo. See it. No directly or specifically made promises. See it. No overt act or threat of force against defendant was proved or claimed. See White v. State. No fear of material or physical harm. Grant v. State, quoting Denmark v. State. It's the Danish baker. It's my case. I knew me and Sarah was soulmates. Supra just means that the case citation has been stated above in the opinion, but it's also a Toyota Supra 2.0. It was the car every guy wanted when I was younger. Yeah, thank you, Bell. I hope it's good. Wait, Baker v. State and Denmark v. State on one page? I know. But Owen just feels this isn't right, so Judge is wrong. Yes, because Owens is a modern progressive lawyer. Facts don't care about your feelings, and feelings don't care about your facts. And feelings always win. Denmark v. State. No hope of material reward, see it. No indication that defense was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th and February 25th. See United States v. Watson. No indication that defendant is mentally deficient, especially considering the verbiage she used, see it. No threats, delusions, deception, or promises, see Martin v. State. And defendant was offered water and brakes, see Chavez v. State. There was no false statements made by law enforcement in order to coerce defendant to go to the police office on February 25th, based on the findings above. Under the totality of the circumstances, defendant statements on 25th was not coerced. Damn. I thought she would get out of that one, because she said so. It's seldom it comes up. Old Supra was a beast. Yes, it was. And I had a buddy of mine who had a Camaro. It could still run away fast from that Supra. People wonder why my wife put up with such a sarcastic perv like me. They just don't know her like I do. No, it's some people like a little bit of sarcasm. Whether the defendant's statements on February 21st were voluntarily made. A statement is not compelled within the meaning of state or federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona. The state must prove by a preponderance of the evidence that a defendant's Miranda rights were waived. Barger v. State. To constitute a voluntary waiver, the state must show 1. That the waiver was a result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And 2. The waiver was made with a full awareness of the nature of the right being abandoned and the consequences of the abandonment. See it. Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may the court probably conclude that Miranda rights have been waived. Factors relevant to consider include 1. The manner in which the Miranda rights were administered, including any cajoling or trickery. See Miranda. Brewers v. State. The suspect's age, experience, background, and intelligence. See State v. SLW. Quoting Farr v. Michael. Dorey v. State. The fact that the questioning took place in the station house, see Drake v. State, and that the fact that the interrogators did not secure a written waiver of Miranda rights on the outset, see Sliney v. State and Taylor v. State. The Miranda rights was administered in a normal tone and cadence. There were no rushed or urgent speech, see Chafin v. State. There was no delay in the administration of defendant Miranda rights. The recorded 25 interview reflects that defendant understood and acknowledged that she understood her rights. See State's Exhibit 1. Defendant acknowledged that she understood her rights. See it. See Slimy v. State. Evidence supported conclusion that defendants voluntarily waive right to remain silent and obtain counsel when officers read defendant his right and asked defendant whether he understood each of the rights, to which defendant responded affirmatively. Hello, Troy Renee. Been a second. You're gonna have Tom CPU on your show. He's OG Karen Reed. Just wondering. Thank you for all you do, sir. I have had Tom on, and Tom and I am always talking about we're gonna do something, and then I have to go to my kids. His co-host gets sick. Tom and I just talked about it yesterday. We need to get together again. That's I like hanging out with Tom, and Jamie loves his accent, so we need him on again. But it's just every time we set something up, something has come in there. Remember, court was closed yesterday, but judge said he'll be there to go over the motions to get them their response, even though it was a holiday. He wanted to expedite it. Court starts Monday. He needs to get it back to them. I should fly in. Girls, can you grift really hard till we're done so I can sell a lot of merch or something so I have money to go to sit with sweet Sarah? Yes, so she can make me $1 million. Tom is an OG on here. Yeah, Tom was, I had Tom on, I think even before the Can Read case started, we had him on a couple of times. Yeah, I don't know. He normally does morning shows as well. What is OG? Old gangster. Will they televise jury selections? Probably not. And again, jury selections, we saw it in one day in one case, and it's just how many in here believe that police officer's testimony is more truthful than anyone else? Okay, 4 of you. How many of you in here thinks that hide and seek is a game you can't play if you lock someone in a suitcase? Okay, 2 of you. And it's because, did he say he had called 165 potential jurors yesterday? It's going to be forever. It's a 4-year-old case. Everyone have heard about it. It's going to be for. I'm guessing court starts Wednesday at the earliest. Where are you and Sarah registered so I can send a wedding gift? And what would you like? Well, Sarah would like if you can get her a fashionable Dr. Pepper tracksuit. And we are registered as Baker and Boone at Beauty at a Budget with Jamie. Show starting tomorrow at noon. Hello, Mr. Gillis. How are you? Hey, Oracle. Sarah will fly me first class in check baggage. Yeah. I can't wait till I'm on trial so I can put it to help Brooks and be a pretend attorney. I'll cover that case. Tom, you had your fun. I'm there to stay. You just flew in, flew out. I'm going in for the long run. Sarah Boone would make a handwritten ad to pay for Owen's fees. Well, at least she would have something. The court reincorporates its findings in U and V herein, which further shows no cajoling or trickery. Defendant was 42 years old at the time she made the statements and appeared to be of normal intelligence. Good sir, I will have you know, Sarah Boone excels at everything she does. Sarah Boone was a straight A student. Sarah Boone was doing puzzles that day. And some of those puzzles said 5 years, and she did it in a week, maybe 2. She is smarter than anyone else in any room she's ever been in. This should be a defamation lawsuit right there. Sarah Boone is not of normal intelligence. Can she sue the lawyer? This is defamation. This is her character is being dragged to the gutter. Everything. Everything. I can hope I could imagine being married to her. Uh, well, what's her split personalities? Absolutely genius and absolutely a genius. We may need the clip of her saying she's good at everything. Sadly, I don't clip enough of all those. But she sucked at hide and seek. She couldn't find Jorge in the suitcase despite him calling out to her. I still haven't figured out why she went with that defense because I would have said, well, I had to lock Jorge into the suitcase because he couldn't count to 10. So that's why I could go hide and he came find me and he never found me and I fell asleep in the closet. Way better excuse than saying we're playing hide and seek and I put him in a suitcase. At least mine gave some kind of explanation to why he died. She should have said, I have 4 people living inside me. One is Sarah, Baker, Sally, and Lola. Well, that's the Letitia Stout defense. Didn't work that well either. Only one of them was a Russian trained Spanish assassin. June, please, you know us guys, we like a challenge. Maybe that's, yeah, it could be like that, but yeah. Yeah, he was really into closing, but again, my name is Maria Sanchez. Don't wear it out. I again, some of the cases we cover, I didn't cover that. I watched it on Dave's, but you're sitting there thinking, "Oh, it's horrible." A kid missing, and then you get the Petco mafia, Maria Sanchez, the place in Florida that can resurrect people like Tupac, the pregnant lady with all the money, the neighbor with the bike who stole the kid. Why, or why do people try these things? Well, differing opinions. There's some indications that something she flipped it over. We know that because it flipped over in the videos, but there's some bruising to his, I believe, his back that could indicate. But I believe they said in one of the pretrial hearings it was an earlier mark. So we'll have to see. Yeah, it's a better one. Why did she video it though? Drunk, I guess. If someone is saying something like this on video, that's what you get when you cheat me. That's how I feel when you strangle me. They're probably not in a correct mindset. That's a problem. She's too good to make mistakes. Uh, February 25th interview did take place at the police station and no written waiver was secured. Under the totality of the circumstances, defendant's statement of February 25th were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of the free choice of the on the part of defendant and was not the product of intimidation, coercion, or deception. And that waiver was made with full awareness of the nature of the right being abandoned. Orders and adjudges as follows. The motion, the amended motion, and the second amendment motion are hereby denied. Done and ordered in chambers, Florida, the 3rd day of October. Michael S. Kranick. I thought they would win this one. I was beginning to listen to those talking heads on YouTube. And some said she has a chance here. But more importantly, because anyone can go on charge for murder, but can anyone look as good as Sarah? Well, she's also asking for a glam squad. And we have that motion as well. It's pronounced Flow Rider. The bruises could have come from her tossing the suitcase down the stairs. Depends a lot on how long he was in said suitcase after unaliving. However, everyone heals differently. It's like body temperatures. Yeah, and again, we know the suitcase have been flipped. We can see that in the video, but the stair things, I don't know, because it's some bruising on the back, and I don't know if there ever have, if it's just something that we kind of started talking about, all of us talking heads on YouTube, or if there's anyone officially ever saying that. I think it's one of those things that just happens along the way. Teresa, have fun with the baby kid, the grandkid. When I grow up, I want to be Sarah Boone. You should be. This was a sure thing, just like Ricada's Frank motion. I don't know who Ricada's Frank is, but yeah, nothing like a sure thing in law. Isn't that something like that? Everyone plays suitcase differently too, apparently. Yeah, and everyone is out there saying you do it wrong just because someone unalives. People are so judgy. Why so judgy? State of Florida, plaintiff v. Sarah Boone defendant. Order on defendant's motion for a right to hair, cosmetic, and civilian clothing without restraints for trial. This cause comes before court, blah, blah, blah. The court having reviewed the motion, having reviewed the court. Come on, one down. Reviewed the court file, having considered the arguments offered by counsel for state and having considered the arguments offered for counsel by defendant, finds as follows. The court provided an ortinus. That's some lawyer Latin, I don't know. An ortinus ruling. Hey, have you heard about Google? I don't know. Try it. MG will beat you to it. The meaning of all tenors is made or presented orally. Oh, so it's an oral ruling. The court provided an oral ruling on October 3rd regarding defendants appearing in civilian clothing for trial and defendants' access to cosmetic and hairstyling throughout the trial. The court reserved ruling on defendants appearing before the jury free from physical restraints. In deciding whether to physically restrain a defendant and what method to use, the court must balance its obligation to maintain courtroom safety against the risk that the security measures may impair the defendant's presumption of innocence, see DSV State, case law. A court may offer physical restraints only if it's found to be necessary to maintain the security of the courtroom. Before ordering a defendant shackled at trial, the trial court must make a case-specific and individualized assessment that considers 1. The defendant's criminal history and the nature of pending charges with specific attention to whether either involved violent acts, 2. Whether the defendant has disrupted criminal proceedings in the past, and 3. Whether the defendant has engaged in any threatening behavior. See Carlisle v. State, case law. There was no evidence that defendant has any criminal history. Defendant is charged by way of information filed on March 23rd with a single count of second degree. There was no evidence that defendant has disrupted criminal proceedings in the past or been a contumacious. MG will cover this tonight. You can hear all the fancy words on his channel. He knows them. Contumacious defendant during court proceedings. See Darfur v. State. There was no evidence that defendant has engaged in any threatening behavior. Orders and adjudges as follows. The motion is hereby granted. Defendant's shackles and handcuffs be removed during trial proceedings. So she won't be wearing leg irons. That's we knew she wasn't gonna have handcuffs on. What? So based on that, I would guess the court won't require shackles. Yes, the motion is. I don't understand if she's innocent until proven guilty. Why is she being held in so high security? Because of the charges against her. If she had been in there with a clean record for shoplifting, 1 bottle of wine, and a suitcase, they probably wouldn't have her in there in as much security thing as she is in now. She's in there for a second degree unaliving. That's why they have to up the security. It doesn't help that you write it the same way. You have to break it down so I know how to pronunciate it. Fundamentous. It means in such a state of fun that you wash your undercarriage while straddling a bush in the front yard. Thank you, Booze. Always here to translate. She wants these pins to work their magic on the jury and maybe make some money on the OnlyFans by flashing the flesh. Julie. No, she has no criminal records because there was never brought charges against her, so they can't use that against her when they rule in this one. But where's the glam squad? He never mentions the glam squad. I don't understand. What? Order on defendant's motion for right to hair, cosmetic, and civilian clothing without restraints for trial, and he only goes into the restraints part. We know the prison said yesterday that she couldn't have makeup on, but this is limbo territory. He granted the glam squad, but he doesn't mention the glam squad in this ruling. But didn't the prison say yesterday that she weren't allowed makeup? I think he reversed his ruling on. Yeah. Okay. Yeah. So he ruled on the glam squad. It's just because it's mentioned in the header of this. Order on defendant's motion for a right to hair, cosmetic, and civilian clothing without restraints. Oh, it's because it's here. That's the oral ruling on October 3rd was defendant's access to cosmetic and hairstyling throughout the trial. If I think I might know what I'm talking about. So yes, there was a ruling that she's not allowed the makeup, which should be applied by the paralegals, where one of them is now a lawyer, because the prison couldn't check to see if anything contraband could be hidden in the makeup. That's what it was. No, he retracted it after the prison guard went up there and said he wouldn't allow it because of the contraband. I'm pretty sure. Yeah, granted, but then denied makeup. Yes, Kilo Chango Charlie. I remember it now. Yes. Okay. Yeah, they can bring her civilian clothes to prison because she must be transported in her civilian clothes from prison. Seems harsh for someone not convicted. Well, that's how it is, because if you want to take that to the nth degree, as you're always presumed innocent, how can you put anyone, even if you capture him pew-pewing 10 people right in front of you, how can you ever put them in prison awaiting trial? Because until that trial has concluded, this is a free man. So that's why you have these, but that's why you can sue after if you are released. Then you can sue for being held without a cause. I believe so. She would have to wipe makeup off. No, I think he said because that's what he said. Could he just take it off before going back? And then you had the bailiff come up and say, "Rah, rah, 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 rah." And he said, "Well, because of contraband, we can't do it." No, because they can't go back there with her, the glam squad. They were only allowed to do stuff to her in court, in the courtroom. They weren't allowed back there in detention area. Well, that's what the judge said you could yesterday, and then the prison said, but we don't know because maybe you can hide, I don't know, a little powdery substance from Colombia in the makeup, so she can get a high or she can smuggle it into the prison. I don't know what, but prison didn't approve of it. She shouldn't be allowed makeup as an inmate currently being housed there. You'd be surprised how drugs can be shipped, and especially in makeup. Jail also has to check her clothes. First, they have a bathroom she could wash her face before going back to her cell, or do they not let her pee? What? Of course they let her pee. Hey, Tispelly and Radiomi. Plus, they were worried she smuggled makeup back in her private pocket. That's another thing. Sarah doesn't need makeup. She needs a pair of very short, very pale pink shorts, a slight hangover, and a bush, and then just an outside faucet. Have a wonderful day, Ernie Birdie. Precautions is allowed to a certain extent. It's a balancing on individual right and the rights of everyone else. Yeah, that's why some can go in. If they clean it off in the courtroom after each day, then it wouldn't be contraband when she's got back to jail. But the problem is, can you conceal and transfer an intoxicant to her via eyeliner? Wouldn't it have to be individually inspected? That there's no go-go powder or anything in the makeup? I don't know. I don't do drugs. I don't know. I don't know. They have female officers. Yes, they have a lot of female officers, but still, it's to minimize the risk of contraband. Day-old makeup on her face considered contraband is interesting to me. Like there's Yeo in the blush, and someone might like it off her chubby cheeks. It could be something like that. And again, it's always on a most secure basis that the because as Boomer says, they stopped allowing people to provide tampons for female inmates because they would soak them with substances that would get inmates drunk or high. So I don't know if it could be one of those, but it's always for the highest level of security they make the stringent rules. Was she offered bail? No, she wasn't offered bail. She actually never had a bail hearing. That's why she lost one or two of her attorneys. I believe it was because I can't remember why she was denied a bail hearing, but that was in one of her pro se. No, before she went pro se, she was yelling at her former. That's before the female lawyer she had. She was yelling at her lawyer for not contacting her brother or something so she could get a bond hearing. I can't remember the full story. Natural beauty don't need makeup. LSD can be put on anything. Well, she is an abuser of substances. So, and again, if you can conceal it, maybe you can slip something in her hair, say, oh, I'm going to put on some gel. if you go to the nearest DEA agent, he will tell you they have seen anything dissolved into everything, so they can smuggle it. I don't know. I don't know. I don't know. I'm just a baker. I don't smuggle drugs that often. If they did that, then her attorney and staff would be in deep. Have you met her attorney? He can't even cite case law for his motions, and he want to be the new MG Law on YouTube. So he would do anything to knock you off the throne as the greatest lawyer streaming. They put drugs on the back of stamps and tape. I've seen it on TV shows before. Think about it. Yeah, but then again, everything would have to be tested, so there's no contraband in it, I think. If you could put go-go powder on your skin, you absorb it. It works as a local anesthesia. Yeah, remember when Joker talked about what he liked to get done with his yayo? Blown up the buttocks. I don't understand that one. Kathy M, you always make me laugh and feel better. I'm a baker, last name from West Tennessee. Love you and Jamie. I wish Jamie was here to hear that today, but sadly, well, not sadly, Jamie is in Alaska helping the wild moose breed. It's their breeding season, and they have been in decline. So Jamie has taken it upon herself to help breed mooses in Alaska. That's why she couldn't make the stream today. She sends all her love and wish she will be back here for Sunday night stream at 4 p.m. where we're going to talk a little more about the Sarah Boone case. Judy will be coming on talking about how she sees all of the stuff with the missing case law. But send Jamie a sweet thought because Greta Thunberg talks a lot about the environment. Jamie puts in a hands-on approach right now in Alaska, helping the moose population grow. Jamie, that's why I love you. Habitat for Humanity, Moose Eye in Alaska. You do it all. Mhm. But do you wear makeup? It's a superpower. I don't know. I think thought her superpower was going to the mall, spending money, and looking at checking out dudes. Michelle Smith denied bail because she wouldn't produce her baggage claim ticket. Yeah. If they put anything like that on her, her attorney and staff would face charges and he would get disbarred. Well, again, he wants to be you. He want to be a YouTuber. That's I think I actually no MG Law is a great streaming YouTuber. That's wasn't to make fun of him, but the other lawyer. When I read his motion for why he took up Sarah's case, that he had seen it on YouTube, I bet you he thinks, oh, it's a really, really great thing. I'm gonna do this case, get famous, end up on court TV as one of their talking heads, and I can have one of these online law channel shows on YouTube. I bet that's what he's thinking, but probably not on this case, especially because I don't think she's gonna win this one. I think he's and he would also find out that just like in court, you need a little more substance to be a streamer. I can get by on my good looks, but the rest of the people are smart people. They're not like me, just idiots living off my good looks. Just wait till I turn 28 and I lose my looks. Jamie is trying to find penguins in Alaska. Yeah, they live with the polar bears. She told us that. Well, that's not completely true. Because Jess has pulled up the facts and whatever where people have gotten that from. This is the newest and most. Tim Sullivan Owens, member in good standing, eligible to practice law in Florida. So he is in good standing with the Florida bar. There's no problem there. Remember in the olden days before beheadings, they would slip the defendant poison. Just take the fun out of it. Jamie is helping with the breeding. Hey, Debbie Bear. All makeup should be banned. It's deceptive and unnatural. Anyone who uses it is being dishonest and can't be trusted. That's the thing I've always said, because all of us guys has woken up with a different woman than we went to bed with. And that's not cheating. But if I'm saying this is 7 inches, I'm a liar. I'm just saying push-up bras, Spanx, makeup, all of that is fine. But if I say 7 inches, I'm a liar. You're not disbarred. Well, there's always a time for disbarment. No, but you know how it is, MG. It's not that easy being especially because you're a lawyer. You have different ethical standards than I have. I can just say whatever I want. Well, I can't, but good luck suing me. I'm in a different country. But you have to weigh it up against and say, well, this is the law and this is what you're taught. And I think a lot of people just think, I can do that. It's really easy to be a law streamer, but it's also very, very hard because there's a lot of technical things and there's a lot of. I have it way easier than someone with a bar card, because I can just make up whatever law I want to do and say, well, it's probably that way. Where you have ethics, and as the British audience know, the only way is ethics. I only get by on my sultry voice, and you do a good job. I like making my wife blush naturally. So by making stupid dad jokes and see her in Walmart, then we shouldn't be able to have beards either. You don't look the same without them. That's why we keep the beard. I got massive hamster chins when I don't have my beard. I'm watching a Danish TV show about the guy who invented electric hair rollers. He supposedly got a Swedish businessman drunk to get a contract. I thought it checked out. That's Carmen Curlers, and now here's good. I never watched it. And actually, if you want to hear something even worse, Bedorowski's people, the sneaky Norwegian people, we had a minister going up there to figure out where the oil fields in the North Sea or North Atlantic, which of them would be Danish and which of them would be Norwegian. And they preyed on our greatest weakness, free booze. So they got the big oil fields and we got the small ones. We on to you, Norway. Let's get back to the good old days where we ruled you and sent you a rotten fish. Exactly. Beards are natural, makeup is not. People dyeing their beard, I agree with you. Shouldn't do that. It looks weird. Well, it's something that you signed a piece of paper that you would withhold, right? What likely happened was there was a due date for the bar fees recently, and there was an error in the system. Okay. What's next today? Brandy Churchwell. And saying Brandy Churchwell, I'm thinking I'm going to ship you all over there now. Go give her some muffins and some love. She has been on a vacation. She's back. She's going to be in court with Sarah Boone. So go thank her for all she does for us. Go listen to her podcast on Canton if you like the Karen Reed case, Brandy makes some of the best content on the YouTubes. That's why she should be at 100,000 subs, not I think she's at what now, 22,000. She should be the biggest of us. She's one of the best out there. I'm gonna ship you all over there and send her some muffins in chat and maybe some donuts and say hi from me. I need to talk to her when she's in court. Hope she's gonna talk to me too. Brandy is covering. I better check before the last 2 times I sent people to channels that already ended. She's talking about someone who found someone who has found a body in her yard that apparently did it on TikTok. So I'm going to ship you all over there. That sounds like an interesting stream. Give her some muffins. Give her some cream pies. Giggity. And tonight, 9 p.m. Eastern, I might join the expert on the best Friday Night Live show out there. Tomorrow, there will be no Stab Your Day. Both my kids had birthdays this month, so I'm taking them out last month. I'm taking them out to dinner tomorrow, so I won't be able to do a Stab Your Day. If I come back and I find something, I might do a later show, but no Stab Your Day tomorrow at 9 a.m. Sunday, 4 p.m., June and I will be doing something on Sarah Boone. June have been going back, getting all the funny things she believes we should look on that her lawyer didn't look at. Some statements she might have given in the interview that probably is going to be used against her in the court of law. But that will be Sunday, 4 p.m. Eastern. Sunday, 6 p.m. Eastern, there's movie nights on my Discord. Join the Discord if you want to have the recommendations and all the stuff. And follow me on Twitch and all the YouTube things I'm supposed to say. Everyone, have a fantastic Friday. Now I'll go watch my football team lose another match. Well, they're undefeated this season. Hopefully it'll stick. But have a wonderful weekend, and I hope I see you somewhere during the weekend. Oh,
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.